Hello, everyone, and welcome. Thank you for joining us for today's Let's Talk Compliance Roundtable, HIPAA breach and penalties. Before we get started on today's presentation, we would like to cover a few housekeeping items. Today's presentation is being recorded for post-event viewing. To ensure smooth presentation, please remain on mute if you are not speaking, and if you feel comfortable to do so, we encourage you to turn your video on. If you have a question for our presenters, please type your question into the meeting chat feature. We will do our best to cover all of your questions throughout the presentation. If you experience any technical issues, please refresh your browser or leave the meeting and join back in. If you continue to have issues, please contact Foley's tech team at videoconferencing@foley.com or dial 1-866-319-5800, extension line 2. As a note, our plan is to only have the slides up for the first 15 to 20 minutes of the program so that we can open up the floor for your questions. A copy of today's presentation will be made available on our event page on Foley.com, and a link to that page will be provided in the chat later on. A short survey will also appear in your meeting chat at the conclusion of the program, and we would appreciate it if you would provide us with feedback on today's webinar to help us improve our future events. And now I will turn it over to Janet Kolarik and Angie Caldwell to introduce our presenters and begin the presentation.
Thanks, Maggie. Good afternoon, everybody. I'm Jana Kolarik, a partner in the Healthcare Practice Group at Foley and Lardner. We are pleased to introduce the joint Foley and PYA Let's Talk Compliance discussion regarding HIPAA breach and penalties. Our Let's Talk Compliance events are in their third year, and we're happy to offer this expert Q&A to you. One of our presenters is Jen Urban, a partner in our Milwaukee office who counsels clients on data incident management, compliance programs, breach response, and other privacy and security issues. Angie?
Hi, I'm Angie Caldwell. I'm a principal with PYA. Our second panelist today with me from PYA is Barry Mathis. Barry, if you want to give everybody a wave. With nearly 30 years of experience, Barry is a subject matter expert in a variety of healthcare IT matters. Today, he'll be sharing his expertise, of course, with you related to HIPAA and security, which has lovingly earned him the nickname Scary Barry. Jana?
So Jen, Barry, and Betty will set the stage, and we do welcome your questions and input as they talk through this important hot topic. So Betty?
Oh, I was on mute, right? The classic faux pas. Welcome to 2021. Welcome, everyone. So great to be with you. This is going to be a really exciting topic because, you know, what's more exciting than HIPAA? Nothing, right? So, you know, we're going to kind of briefly go over 4 main areas. Again, the slide deck will be only up for about 15-20 minutes, but we'll have copies available for you. So we're going to really talk about the audit report, and then we're also going to talk about right of access, which is a really big initiative. And then we're going to go into the new safe harbor and talk about that a little bit more. And then MD Anderson. So hopefully that, you know, kind of gives you a framework of what it is. Just to make sure your chat is working, why don't the group chat in where you're coming from today and joining us from, and then I'll turn it over to Barry and Jen.
Wonderful. Thank you so much, Betty. So we're super excited to talk to you about this today. Again, we're doing slides pretty quick here, but we wanted to give you some framework and background. So first, we're going to talk a little bit about OCR's 2016 and 2017 HIPAA audit reports. And some people may say, why are we talking about something that is so old here? The reality is that this is you know, the information that the OCR uses really to focus its compliance efforts. And so we're going to do a brief overview. These were findings from desk audits, and they focused on compliance with HIPAA's privacy, breach notification, and security rules. The areas where the most material non-compliance were found were in HIPAA's notice of privacy practices, right of access, breach notification, and as we all know for a long time, how entities are conducting security risk analysis and risk management requirements. Next slide, please. Here here are really some of the key takeaways of the findings from the desk audits. The ones we're going to focus in on today are really individuals' rights of access. And I just want to point out in this desk audit, 89% of individuals failed to show they were adequately implementing access procedures. Hence, when we talk in a minute, that's why OCR really has initiated its access enforcement activities. Another big area which has been consistent over the years is really to protect EPHI through security risk analysis and maintain policies and procedures and update this when there's a change in environment and operations. In fact, here the statistics are also pretty dismal. For covered entities, only 14% adequately protected PHI, and for business associates, only 17%. Then with regard to implementing appropriate risk management strategies, again, the statistics are pretty bad here as well. Over 94% of covered entities failed to implement appropriate risk management activities, and 88% of business associates did as well. So while these statistics are a little bit older, they really set the foundation and framework to see where OCR has been going with enforcement actions. Next slide, please. So HIPAA's right of access initiative. We're up to about 18 right of access investigations since 2019. Most of these for background really came through individual complaints. So what's interesting about HIPAA enforcement, everybody asks, well, how does the OCR initiate penalties? How would I even be penalized under HIPAA? Well, it's a couple different ways. One, through individual complaints to the Office for Civil Rights. It could be through an audit process, or most typically where we see is that post-breach of over 500 individuals, the OCR conducts a mandatory investigation, which we will get into deep in the weeds later on. But these are the ways in which penalties could arise under HIPAA. But here, one of the biggest initiatives they had is around access. And really, what were they focusing on? Well, a lot of these instances had just issues of providing timely access to individuals about how information was transmitted to third parties, whether the PHI was in the form or film rent requested. There's been a lot of issues around what fees are proper to charge, and even properly denying access to psychotherapy notes. These settlements have ranged from $3,500 to $200,000, and many of them required entities to undertake a corrective action plan, a CAP, that includes generally 2 years of monitoring. Next slide, please. Just quickly, we wanted to just give you a visual of how these settlements have played out by settlement fine. Next slide, please. So before we get a little bit into the Safe Harbor bill, I just wanted to mention something about actual penalties, and we'll get into the weeds later. But HIPAA penalties have been very confusing over the years. One, because of the way in which they are implemented. It really depends on culpability. Did an entity have knowledge? Was there reasonable cause? Did they willfully do something, and was it corrected or non-corrected? For those of you who have been following this space, there were certain penalties that were set out in the enforcement rule, and then new tiers were initiated under the notification of enforcement discretion, which also could be adjusted for inflation. And I'm not going to get the weeds of those numbers, because when we talk about MD Anderson, it was under old penalty tiers, and now we have new penalty tiers. But the bottom line is this. The most common question I get is, can you give me an estimate of how much I would be fined for doing that? Or I have a breach of 2 million records. What do you think on average? And other than picking up a dart and throwing it at the board, it's very difficult to really calculate that. And why is that? Well, for one, in particular with breaches, after a breach of over 500, The OCR does not just look at the circumstances surrounding the breach. In fact, they look more at what type of compliance program did you have in place in the beginning? What is your most recent HIPAA risk analysis? What did you do with those gaps? Did you develop a risk mitigation plan? Do you train employees? What do your policies and procedures look like that surround this particular situation? Was it you? Was it your business associate? And so I think for all of these years, there has not been a consistent standard to issue penalties because it's really difficult to see behind the doors of what the Office for Civil Rights is looking for. And it really depends on potentially what those entities have done in advance. So with all of that backdrop, I think this new HIPAA Safe Harbor bill, which is HR 7898, was just enacted at the beginning of this year, is so very important. And I will tell you why. I work a ton in the healthcare industry. I've been doing this for 21 years, even wrote my law journal article about HIPAA and the EU Privacy Directive back in the 90s. But everybody always asks me, please, I just want to do what you tell me to do. What can I do to try to prevent penalties and do the right thing? And frankly, there's not a lot of good answers there because, as we all know, laws have a difficult time to try to keep up with best security practices. So that is why this HIPAA Safe Harbor bill is so fascinating and frankly amazing that it is now out there. And what does this do? I mean, essentially it creates a safe harbor for covered entities and business associates that have certain recognized cybersecurity practices in at least for the last 12 months. And what are those? Well, they defer to NIST, they defer to 405D, which came out in the Cybersecurity Act of 2015. You can Google all of those and get some guidance there. But if you're following one of these frameworks or another one that really was promulgated or recognized under some of their statutory authority, it gives you some cover, not all cover. But this makes sense, right? It is really rewarding entities that have taken that time to implement best practices. It could mitigate fines. It could result in the early favorable termination of an audit. It could mitigate in settlement agreements. But on the other end, it doesn't increase HHS's ability to penalize you if you don't do this. But at the end of the day, there's a walk to NIST that is up there on the OCR's website. I mean, in fact, just yesterday, there's a call for comments on NIST SP 800-66 revision 1. There's going to be a comment period that's open through June 15th. And then once revision 2 comes out, there'll be more availability for comment. So we're really starting to see the OCR take a more practical approach because many entities are victims when they have a cyber breach, and we all know there's not 100% cybersecurity. So this is a huge development. Before I turn it over to get in a little bit to MD Anderson, I just want to point out one other thing, not related to the security rule, but there's also major revisions up to the privacy rule. There was a January NPRM that dealt with many, many issues that are relevant. I just want to make sure we have blogs that are up there covering those, but I just want to do a highlight before I turn it over that the extended comment period for this is up to May 6th. So for all of those who've not commented also on the privacy rule requirements, please do so. So next slide, please. I'm going to turn it over now. We have a very surprise guest for you, but first I'm going to turn it over to Barry to introduce our surprise, amazing guest that we're very appreciative is here today. Barry?
Thanks, Jen. Before we get into our surprise guest, you're going to see some synergies between, one of the things we're going to talk about is obviously the Fifth Circuit Court of Appeals opinion in releasing MD Anderson from obligations under their recent, or started back in 2012 and 13, that this is to the heart of it, and that is this safe harbor bill kind of bleeds into this. There should have been some credit given there. There should have been something that was looked at to say, you know, these were some lost thumb drives, this lost laptop. How does that equate to everything else, all the other efforts, controls, policies, procedures, money that's being spent? There's just a complete imbalance there. And you know, I applaud the Fifth Circuit Court of Appeals for recognizing that, recognizing the fact that there's some very specific things that must be proven to HHS and OCR in their investigations, and harm to patients, and you know, release of data, things that just were not proven in that case. Now, I could sit here and talk about it all day, but what I thought I'd do is reach out to someone who knows it much better than I do. Even though some of these occurred before his tenure, I have with us today Chris Belmont, dear friend of mine, who happened to be the Chief Information Officer for MD Anderson while all of this was going on. So Chris, I'll allow you to, if you would, take over and talk about this slide and share with us kind of what happened there in your own words.
Yeah, I'd be glad to. And in the way they kind of set me up here as a surprise guest, there's a lot of things I want to be known for. This isn't one of the most fun things we did at MD Anderson. We did some amazing things. Our team was solid. The organization is an amazing place. But this was something that challenged us quite a bit. And I'll phrase it that way because we had some very unique situations at MD Anderson. Very large organization, obviously with, from some perspectives, a lot of deep pockets. But we had a series of literally 3 events that occurred prior to my arrival. So I'm not absolving myself of anything, but it started before I arrived, and actually the settlement was after I left. So I've been gone for about 3 years. But it consumed a great deal of our time, a great deal of our resources. And even though, and I was telling the group in preparation for this, even though the settlement really reduced our exposure quite a bit, you know, it didn't net out against the total cost of dealing with this, and the time consuming and the opportunity cost of us distracting ourselves from doing our normal business to deal with this and fight this, if you want to be honest with you. A lot of information gathering, a lot of back and forth, a lot of discussions about do we fight it or not. It consumed quite a bit of our time. And, you know, just to give you some references, you know, our security group, when I left, we had about 45 employees, large group. We did a lot of things. I thought we did a lot of things extremely well. But unfortunately, we had 2 of the 3 scenarios was researchers leaving a thumb drive on literally a shuttle bus, and it was one of our shuttle buses. The thumb drive wasn't located, so we did the notification as required and as appropriate. And then the other one was a lost laptop. So these breaches were, not as severe as, say, a hack or a penetration, but still significant enough for us to report and leading into where we are. There's no evidence that any of the information was used or actually acquired. But again, we followed the process, got the exposure, and had to fight through this. So that's sort of the background, Barry.
Yeah. So Chris, let me ask you. You'd mentioned, you know, the deep pockets piece. How much of this was there a sense around MD Anderson that part of this, the investigation, kind of where it led, and certainly the amount that it led to, was part of this just because you're MD Anderson? I mean, you are this icon in the industry and curing and cancer and saving lives, and you're just you're just a beacon out there, and let's set an example. Or,
well, obviously from the inside, we tended to feel a little bit like that. We didn't want to be held up on a pedestal. We didn't want to be targeted. You know, we wanted to protect our name and brand, obviously. We do a tremendous amount of research, where most of this activity occurred was in our research area. So yeah, there was some discussion around why is this happening, and then how hard do we fight it, and keep it in the news, basically. So yeah, there's a lot of discussion from our risk department, our legal department, our compliance group, all the way up through our executive team. You know, what should we do about this?
Yeah, I got to say, I was surprised when I read through, you know, the actual opinion that came out, the resolution, and even towards the last page of that, they make it very clear that there was Health Human Service was unable to prove even the basics of financial harm, patient harm, harm to individuals, any of that. And for those of us who were on the outside in the beginning, when we just heard MD Anderson's got this huge fine, and I don't think that this is just MD Anderson. I think this happens to a lot of institutions. The assumption for us on the outside is, oh my goodness, it must be really screwed up in there. It must be really messed up. These guys are probably having done a risk analysis, and that just wasn't the case at MD Anderson. You guys have spent a tremendous amount of effort and money protecting the data.
Yeah, our when I was there, our budget every year in the security side as a percentage of the department was increasing. You know, we were probably growing 20 to 30% of our security budget each year. And I was there for a total of 5 years. So we significantly increased it. And even during my arrival, we were in the process of locking down things, and we spent a significant amount of time. But, you know, for example, we had 29,000 devices that we managed, you know, on the PC laptop side of the house. And for us to go in, and one of the initiatives we took was how do we lock down those USB ports to prevent that thumb drive. And so that takes time, not only evaluating it, but understanding the impact, making the exceptions, and so on. We did deploy and offered significant numbers of encrypted thumb drives for people to use, but you know, that's a challenge in itself. And then probably the most interesting thing, and again, I'm going to keep bringing up the research side, is, you know, exactly whose data is that? Is that MD Anderson's data, even though these were agents of and employees typically of MD Anderson? They were still doing research typically on necessarily non-MD Anderson grants, for example. So these may be grants that they achieved by themselves. So trying to determine, you know, our exposure from that perspective. And then there's always a challenge of, is this an information breach or is this a collaboration? You know, our mission at MD Anderson was to make cancer history, and we collaborated globally with other researchers, other scientists, other organizations around the world. And you know, when we saw information in flight, it was difficult for us to assess whether that was truly collaborative, meaning sharing with other scientists, getting more data points, for example, or was it truly a penetration or a breach? So we spent a lot of time and energy trying to run through that. So very complex situation.
Yeah, it is one of the more complex, I think, either myself and I know for you have run against in our careers. Yeah. Let's go to the next slide. I want to make a couple of other quick points here. So you guys got fined. I think it was more than 4 points. It started out, I think.
Yeah, it was like 8.
Yeah, they started out 8 million. 4.3 is kind of where they settled. So you guys spent a tremendous amount of time fighting in the beginning just to get it from 8 million to 4.3 million.
Yeah. Yeah.
Okay.
And, you know, again, and I would estimate that with the time and energy and resources we poured into it, we probably exceeded that $8 million target.
Wow. Yeah. So in a way,
in a number of years, I mean,
you got
fined for quite a while.
Yeah. In a way, you got fined the 8 million anyway.
Exactly.
Exactly.
But at least we, you know, maybe kept it amongst ourselves versus giving it out. So anyway.
Got you. Understood. And then, of course, what most of us recognize sitting on the other side of the fence, again, not so much until we saw a little more the weeds of what was happening. In the beginning, the assumption is, well, there must be something really wrong. And then as information began to come out, we're like, wait a minute, you know, this is no different than any other. You know, we've seen so many of our other clients in the same situation. It was just tremendously lopsided.
Yeah, and what was it? I think if I remember right, there's like 35,000 records, which, you know, is not insignificant, but it's also not the largest amount of information that was lost. And, you know, so it was significant.
Right. And again, it wasn't that it was, you know, breaches that were identified in these. This was self-reported because you just couldn't find the thumb drives.
Correct.
Somebody lost a thumb drive and said, I can't find my thumb drive. And you're like, well, being the good stewards of the data, following the rule as it is written, we must then report this and self-report it. I would tell you, I mean, again,
I know where you're going.
Yeah, I'm casting some stones out there. I get it. There's people probably that have been in the same situation that chose not to report it. Okay.
Great.
So the integrity level there, we applaud that. And I think the result of it, even though you guys paid the price for it one way or the other, I think it's helped us in the industry at least understand what can happen and that there is an avenue of recourse there and there is somebody who understands the end result of that. So I want to move to the next slide real quick, and I want to put up a couple of things. These were the two biggest for me, and I'll let you chime in on some of yours and others, even Jen and yourself. But for me, the fact that it took so long to go through the process, it wasn't like other investigations that I've been through in OCR investigations, especially around HIPAA breaches. It's just a little different than Jen had mentioned earlier that it's kind of like the entree into the organization. Because you've got a breach, now I get to look at everything, and that's where these huge fines come from. Once the pinball gets in, it bounces around, right? And depending on the auditor and depending on the state that they're from and the region, it happens in different ways at different times. There's not a lot of synergy there. It's in my experience, and that was one of the things I think that even the Fifth Circuit Court of Appeals understood as well. And then the last bullet, and it's literally like, I think it's on the last page of the order that came out, is they recognize that, look, this is virtually impossible. I mean, here you are penalizing these guys $4.3 million for some people who left a thumb drive on a shuttle and lost a laptop, and you're ignoring the rest of this. How is anybody of that complexity in that organization, that size? It's not a 2-physician practice who has one thumb drive in the drawer up front, right? 29 to 30,000 devices that you have to keep up with, plus no telling how many things people are bringing on their own. I was very pleased to see them recognize that. To me, that was a big, big, big win for the industry.
Yep. Yeah, and then don't forget some of the other smaller points is us being a state entity. It doesn't absolve us from protecting, personal information and patient information, but there is some statutes out there that say, we shouldn't be held to the same. Well, we should be held to the same standard, but we shouldn't be exposed because we are a state entity. There's things like that also popped up that just didn't make sense to us.
Yeah, I go back in my own mind and I look, and I've kind of worked this scenario, kind of a desk audit of my own. Should the current safe harbor bill have been in place when this occurred, I don't think it would have got past the front door.
Yeah.
I think under a desk audit and investigation, I think there might have been a fine there. I think there would have been you should have had something about your thumb drives, yada, but I don't think it would have got to where it was. So that's one of the things.
And our policies and procedures were pretty tight. And I think what worries me about this whole process, frankly, is we're trying to, I don't want to say this, idiot-proof things through technology. But the reality is our policies were there. People tended to walk around it, skirt the issue. We offered, even prior to this, we offered encrypted thumb drives to be used just for protection while we were doing other activities. And people elected to not do that.
How much did technology come into play? Again, 29,000 devices, all these thumb drives. How much, and I know there's other people who are listening who are part of other organizations. They spend a tremendous amount of money on technology, the technical control pieces, besides the administrative controls. How much of the technology pieces were at play there at MD Anderson at that time that were kind of helping keep that gate closed?
We were working toward it. Probably the biggest gap, and I'll be honest with you, I can't tell you this is why we didn't move quicker, but the concept of locking down a USB port, which would have prevented all but the lost laptop, it's very disruptive to the operation of a business. You can think about those of you who are, like this presentation, or if we were doing a physical presentation, the last thing you do before you get on the plane, you leave your office, you stick a thumb drive in there and you grab your presentation for the conference coming up. And you can imagine the number of scientists and world-renowned oncologists that worked at MD Anderson. That's what you do. So we were worried are we considered the business disruption of doing that? Not to mention the fact that we had all kind of devices and everything else to worry about. But that would have prevented probably the majority of this, because it would have been just one lost laptop, probably not hit us as hard as the others. But, we were doing a lot. We had, like I said, 40 folks. We were monitoring logs constantly. We were watching traffic. We could see what was going on, and for us to even identify what was on those thumb drives so quickly was fairly impressive. So we knew what was happening.
Well, I mean, for one, I hate that it happened to MD Anderson, but maybe it's fortuitous, because one of the unspoken things is it's one thing to tell the intern who has his or her thumb drive in the emergency room, you can't do that. How do you tell the lady who is bringing the isotope in that's curing the cancer that you can't use that thumb drive to make this easier for you? I need you to take some additional steps, doctor, to do that. That's got to be a difficult part of the process.
Yeah, it is. And, again, the research side is a challenge because, scientists get their own grants, they have their own bank accounts, they buy their own hardware. I mean, literally, I have one researcher, just to go a little side note. He says, "Chris, guess what? I'm about to buy a supercomputer and put it in my lab." I was like, "Well, I'd rather you not do that. Why don't you put it in my data center, and I'll cordon off a little area for you, and that'll be your real estate. But I'd really like to have my controls on it." But that's the kind of activities that occur, fast and furious. It's their money. They do a lot of things. They may include us, and they may not. So there's a little opportunity there to even if with the best safeguards, still get around it.
Yeah, that's a great story. It's like, Your Honor, I'm sorry we didn't see that thumb drive. I'm trying to keep this supercomputer somewhere.
Or the supercomputer is under the DoD, which is new requirements for researchers.
Oh yeah,
800-171 for all of that research space.
Yeah.
And by the way, that research was split over 2 organizations. So there were 2 scientists, one from our organization, one from another. So again, whose device is that? What protections do they go under? I guess since it's on my building, and maybe you guys are the experts, I should have called you guys maybe in advance. But yeah, so that's just one of many different scenarios that came up that we constantly battled.
I think that's my last slide, and I don't know. I think we're maybe ready for some questions. Jen, I'll turn it back over to Chris.
Well,
thanks.
Sure, Barry. I was going to bring up some other things, and this is from a legal nerdy perspective for all of us that have followed it from years. And I totally agree with everything that you guys have said, but there were some interesting things in the decision of MD Anderson that we'll just have to see what plays out. I mean, I think we're going to get some additional enforcement rules, to give some clarity. We don't have clarity today where this all is going to go, but frankly, it's just going to be a lot more consistent advice. I think we're going to get out of the OCR through rules. But a couple of things. One, as you guys mentioned before, the court mentioned you did have encryption. You may not have implemented across the board, but you can't control every single workforce member. So you did have it. So that was a really interesting point. Secondly, this whole disclosure rule analysis of, so we lost it, but we don't have actual evidence that somebody took it and did anything with that. That goes beyond HIPAA. And, I handle breaches for all types of organizations. And the question always is, well, we don't have actual evidence that anything happened with it. We got no ransom request. We had nothing showed up on the dark web. So it's an issue of, is actual harm out there? That's really a concept that's in all laws, which I thought was very interesting as well in the decision. And one of the other ones is you need to treat entities similarly. This whole, black hole of how do we get to these penalties? It needs to be more clear and consistent to entities. And I thought that was incredibly interesting as well that the court brought that up. So just for us legal nerds, and they also didn't address physical harm, financial harm, harm to individuals' reputation or ability to obtain health care. So the court really called out HHS, OCR and said, how come you didn't address any of those things? And I only emphasize that for entities that are going through this process, MD Anderson case is very important to look through in the event you were trying to negotiate a settlement agreement. Now, I will tell you, I do not take the litigation approach. I recommend to all of my clients to work with regulators, be very respectful, and learn to tell your compliance story. I certainly will say I have seen much success throughout that route, and that is what we recommend. But I do think all of these issues that are bubbling up here with MD Anderson, the safe harbor, are really not just the healthcare industry. It's across the board for all entities that are trying to protect from cyber attackers. Many of these clients are true victims in themselves, and it's how do you work with government authorities to get to that right balance. So I'll stop there. And Betty, you probably have some questions for us, but I just wanted to sum up with me as a legal nerd looking at it from this case.
If you don't mind, I appreciate your perspective on that. That's great information. And the other thing is the process was just drawn out. I mean, even though we were cooperating with them before we even tried to go to litigation, it was just drawn out, and there was a lot of dead air between conversations. Yeah, we'll look into it and get back to you. So we worked with them very hard before we went the litigation route. But it wasn't a give or take. It wasn't. It didn't seem like they had the same sense of urgency as we did. So those are things to remember too. So.
Yeah, I think another
that
part,
adds to the cost of the overall project as well, right?
Yeah, and it's hard also in these situations. Clients ask me, we have to hold monies aside for potential penalties. And how long do you think this is going to go on? Will I ever get closure? I mean, sometimes you never get closure depending on the investigator that you're working with. And it's really difficult, especially for large organizations, to financially predict what is going on or do the correct holding. So I completely agree with you on that one, Chris. And I think
we bought a little Bitcoin way back then. We did. And so maybe that kind of netted things out, but we'll see. I'm not there any longer, so I have no idea what we did.
Great. So we've got a couple questions in the chat. Everyone is welcome to turn on your video if you're comfortable. We really want this to be a roundtable. So, if you're comfortable or, you're sitting in your home office and not somewhere else working from home, feel free to turn on your camera and we'll get the conversation started. So, Nancy made a comment, and so I'll just read you her question. Isn't the premise of the development of compliance programs in the first place, weren't the 7 elements included in the sentencing guidelines for mitigation purposes? I think she's really thinking through. This comment was made during the MD Anderson conversation. So perhaps Barry, Chris, and of course Jen.
Is I got to jump in? I'll let the attorney answer that one since it's got the element in there.
Well, I mean, there are specific standards under the enforcement rule in particular that are supposed to, be viewed. I think, in fact, that is what the court was saying is you didn't even follow necessarily your own enforcement standard. You admitted yourself that I don't know how you guys got to 4.5 million. And frankly, I think, MD Anderson was an example of OCR truly did not penalize anybody for many, many, many years. And then I think OCR got a lot of flack by doing nothing. And so then I think we saw people get into the realm of we're getting a lot of pressure to actually, enforce some penalties. And I don't think that they necessarily followed their own rules, especially on sentencing guidelines, looking at harm, looking at all of these different factors. I think because MD Anderson perhaps had larger pockets and had multiple instances, it was used as a potential good example. But your question is the exact right one, is why wasn't all of this looked at and why wasn't there some consistency and actual harm brought into that decision? And you see that in the Fifth Circuit's decision back.
There was one sentence that they put in there that I think sums it up, is that it was arbitrary, capricious, and contrary to law. And I'm like, that's right there.
Yeah.
Well, that's a review of like an administrative process, when you get to that point, that's typical language, courts will get to, because again, you had to go through the administrative process before it headed over to the actual court. And it was a pretty direct ruling on that piece. So I do think we're going to see additional rules. We've seen that coming out of the HIPAA summit. That we're going to get some new rules soon. And I do think whoever asked this question is exactly, OCR is going to be more careful in its future penalties and adhere to the penalties and the enforcement process that they actually implemented themselves.
Yeah, one of the boomerangs from this could be that, we may be experiencing a little more work on our side, and that dead air may not be there. We may be in a situation where we have to respond quickly. Otherwise, we see some additional, punitive comments or fines even there. So we're a product of some of our own complaints, I suppose. And that if you want it simplified, if you want it regimented, if you want it to be done faster, then we're going to have to answer all that when it gets there too. So there's a little bit of cautious for me on how that's going to go.
Well, that's a very interesting perspective, because if you took out all the dead air and tried to compress that timeline, that was a heavy lift in itself. There were a lot of requirements and requests made of us that were like, wow, how are we going to meet that? So that's an interesting one. If we had to move faster, could we have responded appropriately? So very interesting.
Yeah, that's one of the concerns I've got, is we may be putting a little more on our shoulder than we really want. So
yep, fair.
So, for those of us leading compliance teams at institutions, what should be our takeaways from MD Anderson? It sounds like you put forth a lot of effort, and there was clearly a budget for the security program. Yep. What's the takeaway? What should entities do differently, or is this a deviation from the standard?
Well, I don't know about doing it differently, because I'm sure every decision you make is based on a lot of factors, including your exposure, your potential risk, but also the business interruption, the business disruption. How does it impact your flow and your ability to just do your job and do your business? So, we did that too. But, don't ignore the risk of something like this. Don't assume that, we got things in place and our folks are great actors. Look for those niche solutions like our research area. We knew that was always hard to manage, but could we have been a little more rigid in saying, look, if you're going to do your research on MD Anderson property and you're an employee of MD Anderson, we absolutely have to have access, and we've got to have a process in place. For example, you bringing in equipment and hardware, it needs to fall under the MD Anderson umbrella. So maybe things like that, it may not impact you in your business, but the risk is there. I mean, the risk of a penalty or a breach. So don't ignore it. And sometimes you have to weigh that pretty heavy against the business side of the house.
And Betty, I have some comments on that too. So, and I've done some sessions. So I don't know if anybody's heard of DACRA. It's a CIS control, and it means duty of care. What that framework under CIS is talking about is taking a risk assessment that's technically based and kind of combining it with the law. And what I mean by that is many organizations are doing this duty of care analysis where they're looking at foreseeable harm and negligence to third parties, not just the organization. And when they do that risk harm, they're balancing the benefits and the burdens of security control. So this is going beyond, a typical HIPAA risk analysis where you're doing gaps and risk assessment. It's really doing that risk analysis to say, no, we thought, our mission is research. And so we were balancing these controls and we looked at harm to third parties. And this is what was resulted in. I think that we will move to that type of framework, and it's very persuasive when you're dealing with regulators or court systems post-breach, because you say, no, I knew that risk was foreseeable, but the risk was like, 0.001 and it cost $400 million, and it wasn't part of our mission. So we thought it through. We were not negligent. We actually, we understood that. It's very difficult for regulators and courts and third-party plaintiffs lawyers to go at an organization that took that. So that is a higher level thing, but everybody that's out there, it's free. It's CIS, DACRA, but it's that second standard to try to really bolster your security position from potential litigation or regulatory enforcement. I know AG's offices look at that often now and say, well, we're not going to go after that entity. They actually really evaluated their risk and thought about it. And it's easier to explain in a court when a judge tries to tell you you're negligent, because you always are negligent. There's always controls you wouldn't implement, right? But it's enabled to say, no, we thought that through. We're not negligent, but due to our mission, because people want to cure cancer, for example, in these areas, we did that balancing test.
I would add to the takeaways. One of the things that I see the most of that troubles me, I suppose, is the number of entities that are sitting and saying it's the other guy, it's the other gal, it's not me. They call people like Foley, they call people like PYA after the fact. They've already into it. They're trying to figure out now, what do we do? And don't do that. Don't be that client. Go ahead and contact somebody like Foley, contact somebody like PYA, and start some what if conversations. Start to discover, and this is the acid test that I work with a lot of my clients who say, well, especially the IT folks, because IT folks are famous for, we can fix it with technology. We got it. Don't worry about it. We can do it. It's okay. And what I say is, if you had a breach, could you prove beyond a shadow of a doubt that you were doing everything you could to prevent it? If I put a piece of duct tape over yours and your entire staff's mouth, nobody can say a word. Prove it to me without saying a single word, because that's what a desk audit is, and that's where they start. And if you can pass a desk audit, likely you may not get an investigator inside your institution. But thinking that you're going to talk your way out of it is not going to happen. And I see too many people fail when they go down that road.
Yeah, really, really great points. And, one of the questions from the chat here from Marla is, do you think that OCR is more likely to take HIPAA program compliance into account after a cyber attack or a criminal breach?
Oh, yeah, most definitely. I mean, the OCR said that many different times, is that, again, when you have these incidents occur, they don't per se fine you on 6 million individuals affected or the reason of the breach. They actually take everything into combination about, were you a good or bad actor? Were you doing risk analyses? Did you develop a risk mitigation plan? Were you trying your best? I mean, Chris, years ago, I think, that may not have been the case, but I mean, in my personal experience, I have seen that, or recognition of, are you a very large institution? Are you a small, single physician practice or a self-insured health plan? I mean, I do think that the OCR does take that into consideration, but as you see with the Fifth Circuit, it's like, well, how do you figure that out? There needs to be some consistency that people understand that this is the enforcement structure, and we will see that. There's many questions, and I know we're a little bit over time. I do think we're going to get some clarity out of the OCR with additional rules from HHS specifying the penalties. And I won't get into the weeds, but if you've seen the original penalties based on culpability and you've seen these different levels, I mean, some levels are lower, the maximum level, than the actual what you can be billed. It's very confusing, but we will get clarity, hopefully in rules. I cannot predict when, but based on the safe harbor rule, based on MD Anderson, based on all the other things that have been going on, and I know that they have publicly said we will be issuing some enforcement rules that hopefully will bring more clarity to this. So and then we'll do an update.
I agree with all that, and I'm excited to see some of that coming down the pike. There's a little bit of a placebo in the safe harbor rule, and this comes to a discussion with a client who's excited about that because they've been doing everything they're supposed to. But as I look at some out there that I've been engaged with, and we're trying to turn things around, there's a phrase that the OCR now has plastered on every report that you see the fines coming out, and it's called systemic noncompliance. And that is the organizations who continue to do a risk analysis, but they carry their risk forward year after year. And it could be for a number of reasons. It could be financial reasons. It could be resource reasons. It could be literally they don't have, the know-how to do it, and they've not asked anybody to come in and assist. But when OCR sees that, so maybe you've been doing it the last 12 months, so it's not a guarantee. If you've been doing a risk analysis for the last 12 months and you've had policy procedures in place for the last 12 months, but you haven't reviewed them in 5 years, that kind of thing, there's still some culpability that can fall back on you. So do a little Google that particular phrase. Just Google OCR and systemic noncompliance, and you're going to get all kinds of hits. Be careful of that. It's now, if you're going to look at safe harbor to lean on, you need to make sure you can actually it'll hold you up, because it could also be something that bites you.
Do they consider systemic more than 12 months? Or because, some of these, especially when you got to go through a procurement process and implementation process, and then your own internal audit for effectiveness, that, some of those initiatives take 2 to 3 years. Most
of the systemic noncompliance have to do with things that there's not a lot of conversation. In other words, there's that large gap between we discovered it back in 2017 and we've not even talked about it until 2020, and it's just been sitting there. If you can show, again, if I could put duct tape on your mouth and see that you're working towards that thing that takes for 2 to 3 years, and I can see the efforts, and I can see audit compensating controls, which is an audit phrase that OCR understands very well. If I can see the compensating controls reducing that risk, even though you haven't achieved that goal, then you've got a better chance. But at the end of the day, it's still that auditor's opinion. As far as what is systemic noncompliance, it's that auditor.
And they're looking for a risk mitigation plan. I mean, that's really, and it's not just the OCR, it's other regulatory authorities, because they want to know that you are taking seriously the issues you find from your risk analysis or risk assessment, as it's called in the rest of the world, and developing that into your risk mitigation plan, which then flows up to your enterprise-wide risk management program. And that is a principle that is across the board in cyber. And if you can prove that, again, it's not 100% guarantee, but I will tell you that's where I've had a lot of success, is really telling that story, that you can't correct everything within 2 days because of what you said, Chris. I mean, you can't just go buy a piece of technology and get it implemented immediately. But if you have that living, breathing, circular compliance program in place, it's just more effective. But I definitely think this is a wait and see. I think the good news, as I mentioned earlier, if you're an entity in this process, we are here to help you. I think you need to look at the Fifth Circuit. I think you need to look at some of these concepts, but also be very nice to your regulators to the best you can and work with them. And thank MD Anderson for all the efforts that they've actually helped the rest of the community with to get a little more clarity around this. So again, Chris, I mean, cannot thank you enough for coming and giving you our thoughts.
Yeah, thanks. Thanks for the opportunity. And good luck, everyone. I mean,
Are you still in healthcare? No, I'm just going to ask.
Yeah, I am. CIO at Memorial in Gulfport. So, it's, and we're fighting through some of the same issues. No matter what your size is, you still have the same exact issues. So, thanks for the opportunity.
Yeah, thanks for joining, Chris. I know we're running pretty close on time. Angie, Maggie, can we take a couple more questions, or what are your thoughts? Yeah, a couple more questions. Great. So one of the questions, or the audience members asked, do you think, as a follow-up to penalties for or response to breaches from cyber criminals or cyber attacks, do you think that, especially in response to MD Anderson, that there's more, that the OCR feels that they should fine more because it's due to an employee error? Is the fact that an employee is involved some sort of consideration? Is that something that you can deduce from MD Anderson?
I still think it is still left as gray, to be quite honest. But I do think, and this is interesting and so very important, is that, I mean, we can't be everybody's big brother keeper. I mean, but if you can show in particular to the OCR that you are conducting annual and updated training, and that you're having they actually asked for a mechanism to show, sign-in process, and a lot of this is computerized now. But I mean, they take that into consideration, because I mean, you cannot prevent every single individual in your organization, especially as Chris mentioned, in such large organizations, from not violating policy. But if you can prove that the organization took training very seriously, I think it comes across really well. We all know phishing is still an issue, right? I've had a lot of phishing cases where you don't even know you're reporting like 6 million people and you have no idea because you got to take a large universe. The OCR has been very receptive to saying, well, look, you did all this phishing training, you know, you were doing emails on security incident updates. You actually show all the individuals that were trained in your organization. I think that is the type of message. So while you cannot prevent everything, as long as you're trying to do your best to do so, that is something that I always bring up in that follow-up investigation from the OCR, and it's proven to be successful.
Yeah, and that's a really great point because, you know, I think Barry kind of mentioned the duct tape, you know, desk audit approach. And it sounds like, how do you demonstrate education and training? So Jen, you gave examples of having emails, right, sent. You want to keep documentation of those emails, who was it sent to? You want to have documentation of the employee training. How do you demonstrate in a desk audit that you take training seriously, right? You need to have attestations or some equivalent of that training being conducted. What other things can institutions do from a documentation perspective? It sounds like, you know, when we're looking at a desk audit, to be more prepared for these types of things that's coming up. One of the things I heard was, not only do you need to conduct your risk assessment, but you need to address them, right, Barry? So you can't just have ongoing risks that you're not choosing to mitigate for whatever the number of reasons. What other takeaways could, you know, our attendees here take away from this discussion? And like, how do they, you know, they're leaving this discussion, they're going to go back to their boards, they're going to go back to their compliance managers and teams. What do they need to be thinking about going forward?
I would add back in Jen's comment about a program. You know, what OCR is looking for is not a risk analysis report. If you go back to the 90s, if you go back to early 2000s, what got it done was a risk analysis report. Nobody looked at it. Nobody cared. There wasn't $30 billion thrown in there for meaningful use. You know, so now that we've evolved into this, where interoperability is a big deal, we're sharing data, everybody's concerned. So now we need to shift to, what does the rest of the industry, what does the banking industry do? What are these other, well, they have risk management programs end to end that tie in with the strategy, that tie in with security, that tie in with the clients, that tie in with legal. That's what they're looking for. When someone says, what's your IT risk management program? What's your process? They're looking for that end to end. They're not looking for a report. And I've said that so many times to different clients. Describe to me, you know, your IT information security policy procedure program, and they'll send me a list of policy procedures. I say, great, there's the stack of these. What about the rest of it? Pay attention to the rest of it, because that's what makes a difference, in my opinion, in an investigation. If you can tell the story from end to end with all the documentation, it certainly puts you in a better position. I call it a more defensible position, because things are going to happen. You're going to get breached. You're going to have email phishing. You're going to lose thumb drives. You're going to have employees that do things that you don't know. You know, it's occasionally we hire idiots. We can't help it. Okay, we got big organizations. Sooner or later, you're going to hire an idiot. They're going to do something idiotic, and you're going to have to say, "Well, I did my best to prevent that, but it didn't happen." So documentation is extremely important.
And don't forget all the, you know, especially in healthcare, we're farming so much of our work out now with agencies, with third parties, with managed services. You can have a BAA in place, but still your exposure.
Yeah.
I would love to talk about that. That's a whole new session of, and pay attention to your business associate agreements. They're not silly agreements back in the day. Indemnification, breach requirements. And I would say I represent covered entities and business associates. I mean, in this day and age, business associates are not and should not be taking ultimate liability. I mean, it should be somewhat, it's commensurate to the service that they're doing. But those business associate agreements are very important in how they interrelate with the underlying services agreement, and what authorities are you giving that business associate to do things on your behalf, not just with regard to breaches, but also how may they use your data is incredibly important. And good point, Chris. It's not just you, it's also all the vendors you use, and unfortunately, they're subcontractors too. It just rolls up the chain back to you.
Fair enough.
Yeah, that's fantastic. And so Maggie, I'm going to turn it over to you and Angie now. I think we've got a couple minutes left.
Thanks, Betty. Thank you, everybody, for attending our program. Jana, Angie, is there anything else you guys want to touch base on?
I did want to thank everybody for attending and participating in the event. Yeah, we're planning actually a July hot topic event as well. That's somewhat similar, probably on a different hot topic. Although we want your input. So to the extent you want to hear more about these issues and some of the stuff that our presenters have mentioned, please let us know. Maggie's going to send out an email so you guys can comment on that. We'll also do one in September. And we will do a longer one in January, next January, which will have multiple speakers. So we look forward to seeing you guys and hearing you there. Thanks very much.
Thank you.
And
Thank
thanks
you,
to the
everyone.
speakers.
Thanks,
Thanks to
everyone.
the
Thank you,
speakers. You guys
guys.
did great. Appreciate it. Wonderful.
Thanks.
Wonderful.
Thanks,
Thank
everybody.
you.
Take care.